From Kern Government Television, welcome to this week's Kern County Board of Supervisors meeting, originating from the County Administrative Center located at 1115 Truxton Avenue, Bakersfield, California. Kern County's vision is to create and maintain a customer-centered county government designed to garner the confidence, support, and trust of the people we serve. Today's Kern County Board of Supervisors meeting will convene momentarily.
Board to reconvene. Madam Clerk, please call the roll.
Supervisor Gleason.
Here.
Supervisor Scrivener.
Here.
Supervisor Maggard.
Here.
Supervisor Couch. Supervisor Perez.
Here.
Morning, everybody. We're going to kick off today's meeting with a salute to the flag led by Mr. Michael Rowell. And please remain standing for a moment of silence, meditation, and prayer.
Salute. Flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Special moment of silence for the family and the loved ones and the people in Nice, France, who were so devastatingly impacted. And let's pray that we find the resolve to move in the most appropriate manner possible against the villains who committed that atrocity. Thank you. Madam Counsel, report out of closed session yesterday.
Good morning, Chairman Gleason and members of the board. Yesterday, your board heard item 2 on the board's agenda in closed session. It was continued by unanimous vote to today's closed session this morning, and that concludes my report. No reportable action was taken.
Thank you, Madam Counsel. Everybody can grab an agenda in the back of the room. Please help yourself. And we're going to start off with a review of the consent agenda items. All items listed with a CA above the item number are considered to be routine and non-controversial by county staff. The CA represents the consent agenda for the Board of Supervisors. The C represents the consent agenda for the Kern Sanitation Authority or the Ford City Taft District or any other members or the in-home supportive services public authority. Consent items will be considered first and may be approved by one motion if no member of the board or audience wishes to comment or ask questions. If comment or discussion is desired by anybody, the item will be removed from the consent agenda, will be considered in listed sequence for an opportunity for any member of the public to address the board concerning the item before action is taken. So we'll go through the agenda items, and we'll find on page 2, under resolutions and proclamations, items 2 and 3, public requests, item 5, appointments 6 and 7. Under departmental requests, airports 10 through 12, auditor, controller, county clerk, items 15, 16, 17, and 18. Under county council, 21, employer training resources, 22 through 28, fire department, 29, library, 30, mental health services, 31 through 32, probation, 33, public health services, 34, through 41, Environmental Health Division item 42. The Sheriff Department is 43 through 47. I'm looking for a motion on the consent agenda and to adjourn as the Board of Supervisors and reconvene as In-Home Support Services Public Authority.
So moved.
Is there any member of the public who would like to pull any item off? Michael? 43. We'll pull number 43. Any member of the board? I'm looking for a vote on the consent agenda and to adjourn as Board of Supervisors reconvene as In-Home Supportive Services Public Authority.
Motion.
Second.
Please cast your votes.
The motion is approved. All ayes.
Under the In-Home Supportive Services Public Authority consent agenda, item number 1, proposed successor memorandum of understanding between Kern County In-Home Supportive Services Public Authority and United Domestic Workers of America with a new term from March 31st, 2015 through June 30th, 2017. Any member of the public wishing to pull that item off the agenda? Seeing none, I'll bring it back to the board for a vote on the consent agenda and to adjourn as the In-Home Supportive Services Public Authority and reconvene as the Board of Supervisors.
So moved.
Second.
Please cast your votes.
The motion is approved. All ayes.
Brings us to item 4, proclaim July 17th to the 23rd, 2016 as Probation Services Week in Kern County. Supervisor Maggard.
My pleasure to motion that we approve the proclamation.
Second.
Please cast your votes.
Motion is approved. All ayes.
I am joined this morning by T.R. Miracle, our Chief Probation Officer, and it is my pleasure to bring before the board the opportunity for us to proclaim July 17 through 23, 2016, as Probation Services Week in Kern County. The Kern County Probation Department plays a pivotal role within the justice system in collaborating with virtually every social service and law enforcement agency. Probation officers are problem solvers, crime prevention specialists, motivators, educators, facilitators, and oftentimes they are the only support system that an offender may have. Now, why would we be concerned about what support system offenders have? Because it is absolutely in our best interest for these fine men and women to help make sure that they do not reoffend. Using the continuum of services provided through different methods of prevention, intervention, suppression, and incarceration, the Kern County Probation Department is working daily to achieve their motto, commitment to a safe community. So, TR, it is my pleasure to present you with this proclamation from the Board of Supervisors representing the County of Kern and the State of California, as we have officially proclaimed July 17 through 23, 2016 as Probation Services Week in Kern County. This has been entered into our official minutes, evidenced by the signature of our chairman, the Honorable Mick Gleason, on the 19th day of July, 2016. Thank you for all you and all the folks that work with you do. Please tell us a little bit about this week and tell us more about how we can demonstrate our pride in your forces.
Thank you, Supervisor Maggard, members of the board, and congratulations to Supervisor Perez. I really appreciate this opportunity to recognize the staff of the Kern County Probation Department. Probation is a key component in our criminal justice system. Most people are familiar with the front end of law enforcement and with the court system. However, the truth is probation plays an integral part in every criminal case. Probation is very unique because of its dual responsibilities of both enforcement and rehabilitation. Our duties are incredibly diverse and have only increased because of AB 109. We supervise approximately 10,000 adult felony offenders, over 2,000 juvenile offenders. We operate 3 separate juvenile facilities in Kern County, and last year we did approximately 5,000 juvenile adult sentencing reports. In addition, we run a juvenile court work program, supervise minors in out-of-home placement, and provide evidence-based programming both in custody and out of custody, such as in our day reporting center and through our adult programming unit. We take pride in our collaborative partnerships, working with law enforcement, superintendent of schools, mental health, community-based organizations, and many, many more. We realize we can't do it alone and that we're stronger when we work together. We have over 150 armed officers who go into the field every day to protect the community by ensuring probationers follow the terms of their probation. These officers complete evidence-based assessments and create individual case plans to provide a path towards rehabilitation and reducing recidivism. Yet they stand ready to bring offenders back before the court when offenders fail to take advantage of this opportunity. We have other officers who work in the court setting, preparing sentencing reports and making recommendations, and assisting the court in a myriad of other ways. Still, other officers work in our juvenile detention facilities, supervising and counseling youth, attempting to turn their lives around. Every officer and every support staff is vital to accomplishing our mission. I am extremely proud to be chief of a department with such an amazing and hardworking staff. Every day they face difficult, dangerous, and challenging situations, yet they persevere to make a real difference in our community, and they deserve to be recognized. Once again, I want to thank the board for this proclamation and your continued support for the important public safety work that the Probation Department does. I pledge to you that the Probation Department will continue to be innovative and resourceful, and that our staff will do all they can to make Kern a safer and better place to live. Thank you.
Thank you. We're proud of them as well, and thanks for all you guys do.
Thank you, Supervisor Maggott. TR, I can't tell you how proud we are of you and your team, and it's so great to see a department of ours moving in the positive direction it's moving under your leadership. Thank you very much. Okay, moving along. Takes us to public presentations, item number 8. This portion of the meeting is reserved for persons to address the board on any matter not on this agenda but under the jurisdiction of the board. Board members may respond briefly to statements made or questions posed. They may ask a question for clarification, make a referral to staff for factual information, or request staff to report back to the board at a later meeting. Also, the board may take action to direct the staff to place a matter of business on a future agenda. Speakers are limited to 2 minutes. Please state your name and spell your name before making a presentation. Are there any takers for public presentations? Seeing none, we'll move on to item number 9, board member announcements. Seeing none, we'll move on to animal services, item number 13.
Mr. Chairman?
Yes.
I think it's, well, although we did it yesterday, it was in a much less public setting. All the members of the board want to congratulate you on the birth of your child and the incredible demonstration of what it is to be a woman and balance all the things that you balance in life. So congratulations on behalf of all the members of the board.
Oh, thank you, Supervisor. That's very gracious, and thank you to my colleagues, our chairman, who has been so accommodating and so gracious. Really appreciate you. And a special, huge thank you to the incredible guardian angels at Kern Medical, who have been great friends and great partners with my family. So thank you.
Thank you. Thank you, Supervisor Maggott. Well done. Brings us to item number 13, Animal Services. Public hearing to consider repeal of uncodified ordinance G-7997 and enact a new uncodified ordinance relating to proposed fee adjustments for services to the public provided by the Animal Services Department. Mr. Cullen.
Chairman Gleason, members of the board, good morning. Nick Cullen, Director of Kern County Animal Services. The Animal Services Department last increased fees on January 12th, 2010. Since that time, I'm sure many of you may be aware, many significant changes for the department have occurred, and the cost of basic services and supplies needed for shelter operations have increased. The operational changes associated with moving toward a no-kill shelter has increased the cost of caring for the animals in order to facilitate a live release, and that does include spay and neuter, veterinary care, general feeding. These fee increases requested will help to offset the increases in costs that are a result of these efforts, and I am available for any questions that may be brought forward.
Thank you, Mr. Cullen. Anyone in the public wishing to make comment? Yes, ma'am. Please come forward and state your name.
Marilyn Stewart, Director of Alpha Canine Sanctuary. I haven't been here to brighten your day for quite some time.
Thank you for being here.
This is about the proposed increase from $150 to $450 for our annual inspection fee. And just a little bit of background, Alpha has been rescuing dogs for almost 21 years. Conservative estimate, very conservative, is that in that time we've rescued at least 6,700 dogs, and those are animals that have been diverted from animal services, have never entered a municipal shelter. Given that animal services spends an estimated $300 for each impounded dog, we've saved the taxpayers more than $2,028,000. We hear that community involvement is needed to reduce pet overpopulation. Well, here we are. We're the community. Of this community, started here, supported entirely by the community. So perhaps you could see your way clear to not have this increase. We save you a lot of money, and we're happy that that goes into your pocket, but this $300, which I know it doesn't sound like much to you, does to us, it comes out of our pocket, and let us keep that. We can make that $300 go further than you can. Thank you.
Thank you.
Good morning, Mr. Chair, honorable members of the board. Haven't been here in a while either, so I'll introduce myself. Liz Keough, proud resident of the 5th District, and congratulations, Supervisor. I'm here to discuss, as Marilyn has, the increase for the facilities that have 50 to 100 dogs. I've known Marilyn ever since she established Alpha Canine out at Granite Road. She has a wonderful facility. Very early on, she was pulling animals from the county shelter, and one of the ones she pulled wound up in my house. I had that girl for 12 years. She was one of the most wonderful dogs I ever had. I guess I'm looking at it, you've heard the expression, no good deed goes unpunished. When you look at what Marilyn has done over 20 years and suddenly hit her with an increase of 300% in the facility fee, I think that that is a slap in the face to someone who has done so much for our community. She is the original rescue in Kern County. She paved the way to show other people how you can run rescues, how you can help the county. I know that in the ordinance proposal, the very last item is number 8. It's the same as it has been for a number of years, and if my hands could work, I could quote it to you. Oh, Lord. It says fees may be waived. Now, this refers to all fees. Let me back up a little bit. For example, you have in this ordinance the fees for adoptions. Those fees are rarely, if ever, charged because the director, under item 8, for special events or circumstances in the interest of advancing humane purposes, can waive or reduce those fees. I believe that Director Cullen does have the authority to change any of these fees that you pass, and I would urge that the case of Alpha Canine Sanctuary be carefully looked at. I don't believe that the inspectors have ever found a problem with the way Marilyn runs her operation, so it's a quick in, out, but she has to fork over $450. So I would appreciate your, now, on the other things, the rabies shots and all of that, we've really been losing money because it's not just the cost of the product, but the personnel involved in filling out the forms, giving the animals the shots and all of that. So I guess I would urge you to urge Director Cullen to pay special attention to the Alpha Canine situation and the good work that Marilyn has done over these years. Thank you for your attention.
Thank you, Ms. Keough.
Chairman Gleason, if I may. Oh.
Michael Rao. Most of these fee increases are minute in numbers, but there's a couple of them that are way over the top. And when you look at page 3, D, the commercial animal facilities, it's way over 100% increase. And you look at page 4, you're looking at E, animals, large animals over 25 pounds. The increases are pretty heavy, and I would wish you would consider that.
Thanks, Ralph. Anyone else? Thank you. We'll close public session. And Mr. Cullen, do you have any general remarks before I bring it to the board?
Just to make a comment on what Ms. Keough had stated and about Alpha Canine. Ms. Keough is correct. The fees in the animal services structure are subject to change at the request of the director. Alpha Canine, as well as several other rescue organizations and sanctuaries in Kern County, are of the utmost importance to advancing the humane goals that the Animal Services Department has, and we will look at those cases on a case-by-case basis, alpha canine included.
Thank you, Ms. Cullen. Bring it to the board for comment and consideration. Ms. Couch. Supervisor Couch.
Thank you. Don't we, when it comes to public health department, when they are doing their inspections, they're now focusing on the establishments where they're having a problem. Right? Hotels rings a bell with me, something along those lines. So I guess I'm asking if you have the discretion in this, with our action, that you could implement a similar type of program where you have someone who's been a good actor, has never had a problem. Do you even need to inspect them annually, or could you do something along the lines that we've done with in the public health department?
Supervisor Couch, through the chair, absolutely. We can look into what we have been doing in animal services, looking at things different than we have before. The commercial animal facilities are, they're not something that we seek out. Those commercial animal facilities are most often applications that are submitted for an inspection on those properties. But as I said, most often if somebody's submitting an application for a commercial animal facility permit, they have a decent facility. So, but absolutely, we could take a look at the way we investigate those animal facilities, and if there's changes that are appropriate, we'll make them.
Supervisor Perez.
Thank you, Chairman. Nick, thank you for your hard work and in particular the partnerships you have really built over the last couple of years with Liz and a whole host of folks that we know have been doing this for a long time. They predate us, although I know you've been around for your fair share of time. And, you know, I really have every faith that you're going to continue along the same lines of working with these groups to do what's natural and intelligent and incentivizes the continued incredible sacrifice from these groups and devotion that has really caused us to be where we are today. I know that you know that and believe that, and I feel very passionately about the encouragement of these groups and the protection really of their investment that they have made over the decades, and because we need them moving forward. We've made incredible progress with your leadership, still have a long way to go, and where this board is deeply devoted to getting us to no kill and making the kind of changes that demonstrate, you know, our humane approach to the welfare of our four-legged friends and how important this is for Kern County. So, Liz, I have every confidence that you'll bring these issues to my attention swiftly, as you usually do, and that as issues arise, you continue to inform us and let us know what the impacts are on the ground. So, Nick, thank you. And appreciate your continued partnership with these groups, as they are so integral, and it's impossible to get to the end goal without them. So thank you, and I'd make a motion on staff's recommendation. But Liz, I'm sure that you'll keep me very posted. Thank you. I count on it.
Second.
Motion is second. Motion is second. Please cast your votes.
Motion is approved, all ayes.
Brings us to item number 14, audit of compliance and internal controls of Kern Medical's cash for fiscal year ending June 30th, 2016, and department's response. Ms. Bedard.
Good morning, Mr. Chairman, members of the board. The audit before you is a limited scope audit of Kern Medical's controls over cash. The report contains a modified opinion. We identified 4 significant deficiencies. In the previous cash audit we did of Kern Medical, there were 5 findings related to the scope of the current audit. 4 of those findings are repeat findings, 1 being a partial repeat finding. That concludes my remarks, and I'm available to answer any questions you may have.
Thank you, Ms. Bedard. Anybody in the public wishing to make comment? Seeing none, I'll close the public hearing and bring it back to the board.
Motion to receive and file.
Second.
Please cast your votes.
Motion is approved, all ayes.
Thank you, Ms. Bedard. Brings us to item number 19 under County Administrative Office, request for approval of joint exercise of powers agreement creating the Indian Wells Valley Groundwater Authority. Ms. Lawson.
Mr. Chair, members of the board, County Council will be briefing you on this item.
Thank you.
Good morning, Chairman Gleason and
morning.
members of the board. This is the time set for a public hearing for your board to consider and decide whether the county should approve a joint exercise of powers agreement to form the Indian Wells Valley Groundwater Authority to be the groundwater sustainability agency for the Indian Wells Basin. If your board votes to approve the JPA, we ask that you also appoint a representative and an alternate to serve on the board of that GPA. A little bit of background very quickly. SGMA, the Sustainable Groundwater Management Act, allows eligible public agencies to form groundwater sustainability agencies in order to implement SGMA. SGMA is a state law that provides for and anticipates that local public agencies with water supply, water management, or land use responsibilities within a groundwater basin that has been designated by the California Department of Water Resources as medium or high priority basins will form a groundwater sustainability agency for the purpose of achieving groundwater sustainability through the adoption and implementation of a groundwater sustainability plan. In this case, the Indian Wells Valley Basin has been designated as a critically overdrafted basin. As a result of that designation, SGMA requires the Indian Wells Valley Basin to have a designated GSA no later than June 30th, 2017, and an adopted GSP, Groundwater Sustainability Plan, no later than January 31st, 2020. It accelerates the timing. In this case, there are 5 eligible agencies with elected officials who are accountable to the public through the public election process, who have indicated a desire to form a joint powers authority to operate as the legal vehicle to become the GSA for the Indian Wells Valley. Those elected public agencies are Inyo County, San Bernardino County, Kern County, the City of Ridgecrest, and the Indian Wells Valley Water District. To date, 3 of those entities have already voted to approve the joint powers agreement that is before your board today. The remaining entities to consider the agreement are the County of Kern, your board that is, and the City of Ridgecrest. The CAO has prepared a very good board letter that explains SGMA and the JPA to you. It also attaches a copy of the proposed JPA agreement. You will see that it contains numerous provisions that are highlighted in the CAO's board letter, so I'm not going to go over those in detail with you. Based on the foregoing, and I'm going to have Deputy County Counsel Phil Hall talk to you about a couple of non-substantive changes, including some typos that we want to have corrected before your board considers the actual agreement. However, with those non-substantive corrections, based on the foregoing, we recommend that your board, 1, make a finding that this matter is exempt from further CEQA review pursuant to sections 15061B3 and 15378B5 of the state CEQA guidelines. 2, approve the joint exercise of powers agreement, which creates the Indian Wells Valley Groundwater Authority. 3, select a representative and an alternate to serve on the Indian Wells Valley Groundwater Authority Board. 4, adopt the proposed resolution that is submitted with the CAO's board letter. And 5, authorize the chairman to sign the JPA. Your staff is in support of the JPA, and our recommendation is that you move forward with it. And with that, I'm going to turn it over to Deputy County Counsel Hall, who is going to describe very briefly the minor non-substantive corrections to the agreement. Thank you.
Thank you, Mr. Hall.
Good morning, Chairman. As County Counsel Goldner stated, these are very minor changes. They consist of an updating of the table of contents and addresses to being added on Exhibit A, which is the agency addresses, so that notice can be sent to those agencies if required by the JPA. And that's it.
Thank you, Mr. Hall. Ms. Goldner, are you done?
Yes, I am. Thank you.
Thank you. Before we open it for public comment, what I would like to do, I would like to open it for public comment and start off in Ridgecrest because I believe we have somebody up there. Chainsaw, you up?
Yes, sir. Ms. Decker is here, but would like to not speak at the moment.
That means she does not want to speak, Denny?
Yeah, that's correct. She does not.
Thank you, sir. Appreciate it.
Thank you.
Okay, now we're open. The public session is open. Anybody wishing to make comment, now's your chance.
Good morning, supervisors, board, and staff. I'm here to put into the record 2 documents.
Donna, could you please state your name, please, for the record?
Okay, Donna Thomas. Okay. I am a director on the Eastern Kern County Resource Conservation District Board, and I'm here to put 2 documents into the official record for this JPA GSA formation document. The first is a letter that's included in the enclosures. It is the 3rd letter dated June 22nd, 2016, from the State Water Resources Control Board. And it states the status of East Kern RCD as a local public eligible agency to participate in GSA formation. The second letter I'd like to read, signed by the president of our board, Don Joe McKernan. And this is the result of a special meeting held by our board yesterday and a vote of the board. At a special meeting held July 18th, 2016, the board of the Eastern Kern County Resource Conservation District, EKC-RCD, voted to respectfully request that the JPA for the Indian Wells Valley and adjacent counties request consideration of appointing EKC-RCD as an associate member of said JPA. Enclosed, please find documentation that EKC-RCD has the responsibility for its district to provide expertise and technical assistance to help make decisions for the good of the people within the JPA boundaries. We also respectfully request your consideration for an MOU with the JPA signatories to expedite this matter. And we were looking especially at section 9.08, subsection C of the current JPA agreement. Just as comments, personal comments, myself as a director, we feel that the makeup of our board represents a cross-section of stakeholders. We have a director who is an ag producer, a director who is a water hauler, a director who represents Domestic Well Owners Organization, and past directors of the Indian Wells Valley Water District who are currently serving on our board. We ask that you seriously consider inclusion in the current document. We don't want to wait for down the road acceptance. Thank you.
Thank you, Ms. Thomas.
Good morning, Mr. Chairman, members of the board. My name is Derek Hoffman. I'm an attorney at Gresham Savage. We represent Meadowbrook Dairy and Meadowbrook Mutual Water Company, and we submitted a detailed comment letter yesterday. I hope that the board has had a chance to consider our letter, and particularly attachment A to the letter. On behalf of Meadowbrook, we urge the board not to adopt the JPA today in its current form. Instead, we ask, as we've asked for many months, that the JPA language be minimally revised regarding the committees to clearly establish a groundwater sustainability plan development committee that will also provide for truly meaningful participation. And in so doing, to define generally the membership, the functions, and the duties of such a committee, and provide that it would act to develop or participate in the development and implementation of the groundwater sustainability plan. The language in our proposal, as attachment A to our letter, lays that language out before you, and that's our request. In our experience, Kern County, frankly, has led this GSA formation process in a way that has systematically excluded private pumpers. You're hearing today, and you just heard from Ms. Thomas, a theme here, which is we're asking to come under the tent, to be let in the door and given an opportunity to participate in a collaborative way in developing the groundwater sustainability plan for the Indian Wells Valley. Meadowbrook is one of the largest pumpers in that valley. And originally, we came to this board asking for a voting membership position on this JPA and the GSA. When that proposal was rejected and discussed, we considered the alternative of participating on this GSP development committee. And in fact, in February, your board directed staff to ensure that the GSA includes meaningful participation of mutual water companies and private well owners by providing for their participation on a groundwater sustainability plan development committee. That was the direction that was given. Unfortunately, what we've seen since then is that the language in the JPA document, particularly section 7.04 regarding committees, has been watered down to a point that there is no such thing as an express groundwater sustainability plan development committee. There's no explanation of what its general membership would be, and more importantly, there's no discussion about what its purpose, function, or role would be regarding the development and implementation of the GSP. Meanwhile, while that language has been watered down, we've observed evidence in the record, statements made by representatives of Kern County during the closed GSA formation meetings that we've asked to be part of, but were not invited. Those statements include, and I'm just going to share a few brief quotes. The vision is that GSA staff will prepare a draft GSP. The GSP formulation will lie with staff and not a development committee. The GSP development committee is really a citizens advisory committee. So those statements give us a lot of concern, and while we've heard a lot of comments given to us that will get taken care of, that you'll be included just later down the road, the actions speak louder than words. And what the actions reflect are language in the JPA document that do not provide assurances for private pumpers, large and small, to participate in the development and implementation of the groundwater sustainability plan. I just want to point out as well that our proposal, as reflected in attachment A to our letter, and this groundwater sustainability plan development committee is not designed to give private pumpers an edge. It includes the JPA elected, or the JPA members. It would include Kern County. It includes seats for the associate members. It also includes seats for the large private pumpers and small domestic well owners. We've taken a very collaborative approach here. We're trying to create a GSP development committee that really does establish meaningful participation and does so in the Joint Powers Agreement itself. Now, I'll just close by pointing out that Supervisor Gleason, Chair Gleason, with respect, on June 7th, you indicated that your main theme is fair representation of people in the white space, and that's Meadowbrook. You've also indicated that we're pressed for time, and with regard to that issue, we feel that there's plenty of time. There's plenty of time to minimally revise the JPA as we've requested, to do it right, to establish a clear GSP development committee as a committee of the JPA board, and to do so now, and then elect to become a GSA. What we don't have time for is to do it incorrectly. We don't have time, this valley does not have time to establish an inadequate GSA that's not broadly representative and fails to bring in the private pumpers and small domestic well owners into the process meaningfully. A failure to do that will put us, and has put us, on a path toward conflict rather than collaboration. So in closing, again, we urge the board not to adopt the JPA today in its current form, but instead to tap the brakes, take a little time, consider our comments and propose revisions to the JPA, and establish that GSP Development Committee now. And we're concerned that all the evidence in the record before us indicates that at this point, neither Kern County nor the prospective JPA members has any intention of including the private pumpers in the GSP development and implementation process. We're asking you to show us otherwise. Thank you for your time.
Thank you, Mr. Hoffman.
Good morning. My name is Rod Stiefvater. I think you have that in the record, so I don't have to spell it. I would just like to appear and state that what was just stated by Meadowbrook's representations and the process that they've gone through. There has been a lot of communication back and forth between both Meadowbrook and ourselves. We feel very similarly, as does Meadowbrook. We feel excluded from the process. We feel that the JSA, the GSA will not give us any direct representation whatsoever, even though we're a major groundwater pumper, and will be even more so in the future. So we ask you to heed what was just stated, to give us some input, which we've had none, to proceed with this process. It's supposed to be in a collaborative basis, but in our opinion, thus far, has not been at all. We are very uncomfortable with the county being our representation on the GSA. And so again, I would ask you to seriously consider what was just stated, as that's our position as well. Thank you.
Mr. Stiefvater, can I ask you a quick question? Sure. Please? You said uncomfortable with county representation?
Yes.
Could you explain that, please?
Well, Chairman Gleason, you've made numerous comments to us of your desire not to see ag in the valley. Those sorts of comments to us indicate a desire on your part to exclude us. You've excluded us in this process, and we suspect that you will exclude our interests in any votes that you make on what is probably going to be your position as chairman of this GSA. So when you look at that sort of a situation, when we're a major groundwater pumper, then certainly we feel that our interests are in jeopardy, and that our feelings will not be heard.
Thank you, sir.
Sure.
Anyone else? Yes, sir.
Thank you, Mr. Chairman. Thank you, fellow supervisors, for this opportunity. Benedict Lubon with Jude Benedict and Associates. I represent companies that separate water, clean water. They're clean energy, clean technology companies. I was here last, election day. There were more people here that day. And you had it was a long day. We all had a long day. It's good to see that there's less people here. But Supervisor Maggard asked about oil field production water. And then later on in the afternoon, you wanted to know more about JPA's, Joint Powers of Authority. And I've promoted joint powers of authority all over the state. And what we really need is another source of water. And if we can take this oil field production water and use it for beneficial reuse, then we have another source of water. We're creating more jobs. And it's tough because there's so many agendas in here. You know, the beauty of Kern County is we have agriculture right next to water, right next to oil. And it all works together. And the beauty of a JPA It brings this coalition of people and government entities together to create more money. And the money's there. Prop 1 money is going to become available on December 16th, 2016. It's very close. However, at the same time, we have the Central Valley Water Quality Control Board having a food safety issue. You know, and the expert panel, it's going to take their time. Well, we don't have time. And the beauty of a JPA is, first, you minimize the risk, because who wants to pay for this? Not many people want to pay for it. Everybody wants to, oh yeah, we can clean the water and we can make money on the water, but to actually do it, who pays for it? And so the beauty is to have a county be a lead government agency, and then there's other oil-producing counties. We could have Los Angeles, Santa Barbara, San Benito County, all join us, and all those municipalities. But we have a tax base that minimizes the risks. And all the stakeholders, we have lots of stakeholders involved. And it's like herding cats, because all these cats have little laser beams on their heads, and they're all shooting everybody. And we need to learn how to cooperate, but a JPA does that. And in forming the JPA, then we're able to go to the state, and we can get the Prop 1 money. We can also get cap and trade money. And the money that we get, we can match at the federal level and the state level. And so I hope that we can further this action along. I will write all your offices and speak to your staff, and hopefully with you. And we have a lot of bright people working in this county, and I'll reach out to them, and hopefully we can advance this train of thought and move it forward. And somehow, the issue you're speaking of right now, I'm speaking of an additional source of water, but what is happening with the Sustainable Act? Somehow we'll find a way to blend that, because we need that new source of water. We're still in a drought. People don't think we're in a drought. We had a rainy season. We had El Nino came by. The dams are high, but we're in a drought, and we'll be in a drought for a long time. So I've planted a seed, and I look forward to nurturing it forward. Thank you.
Thank you, Mr. Lubon. Any other takers? Okay, excuse me, I believe we have someone in Ridgecrest.
Yes, sir.
Okay, Danny, what do you got?
Judy Decker, just a moment.
I'm going to sit over here. Oops. Good morning, Chairman Gleason and the rest of the board. My comments are mostly for the rest of the board.
Could you please state your name, Judy?
Oh, excuse me. Yes, thank you. So, thank you, Mick. My name is Judy Decker. I have property in the city of Ridgecrest and in the county. And my comments to you are, unlike your side of the valley, we have been in overdraft for almost 60 years. We are drinking water that was laid down much, much earlier in geological times. It has been age dated in some areas to 26,000 feet. We have no river running through our valley that has any water in it anymore. And it is critical for us to move forward on the GSA. You heard from Mr. Stiefvater, you heard from Derek Hoffman. They both are large agricultural interests that are pumping a lot of water. I'm here for myself, but I'm also a member of the RCD board, and I will say that who's left out of the picture are the domestic well owners. As the water is continued to be pumped from all of the large pumpers in this valley, which include the Indian Wells Valley Water District, It is the small well owner on his 2.5, 5, 10, 20, 40 acre parcel that is going to suffer and is already suffering from lack of water. I believe that you should choose your representation for the JPA, voting members, associate members, and others very carefully. It needs to be equal representation, or a group of people will lose out. We don't get any water from outside. We import no water. This is critical in your decision because we have no backup. And in closing, I would like to say, remember, the jewel of the Navy is here in the Indian Wells Valley. It needs to stay not only for the people of the Indian Wells Valley who either work there now or worked there in the past, but for the defense of our country. Thank you.
Thank you, Ms. Decker. Anybody else from Ridgecrest?
No, sir. That concludes the comments here.
Thank you, Denny. Anybody else from here? Seeing none, we're going to close the public hearing and bring it back to the board for comment and consideration. And I think it's probably on me to start talking because it's my district. Thank you all. Let me start off with the most poignant thought I have, and that's the response to Mr. Steve Fodder. Thank you, sir, for coming in and expressing yourself. I know that wasn't easy. I put you on the spot, and you came across in an open, honest way. I hope, if nothing else, sir, you get the same respect that you gave me that I'm going to try to give you. And that is this. You asked specifically for some input, that you're going to be part of the solution. You or I think you meant not just Mojave Pistachio, but I think you were talking about large agriculture in the valley. I had spoken many times about the fact that we are going to form a GSP, and you've heard all members of the GSA clearly articulate that we're going to form a GSP development committee that will be among the first words that come out of my mouth at our first JPA public meeting will be to assert the membership of a GSP committee. So, and you will have an opportunity to become you or a representative that represents you and your interests will have a large agriculture will have an opportunity to be present and have a vocal voice in developing our GSP. Let me further say, sir, that I don't believe it's possible for us to find a solution in the Indian Wells Valley without farming becoming a critical component of that solution. Let me say further, sir, that I have never, to my knowledge, ever said that I want ag out of that valley. If I did, and if you heard that, my apologies, it was a misstatement on my part. And I don't know where you heard that, but I don't ever remember saying that. I remember arguing vehemently against that because of all the businesses that surround large-scale commercial agriculture in the valley. But thank you for your honesty. I also, okay. Mr. Hoffman, thank you, sir, for your representation. I thought it was good. Could we please have from County Council a legal definition of the word meaningful participation? Because I want to be clear in that the comments were made about conflict, vice collaboration. There were accusations of things that I don't think happen at all, but other people, I give them, they see things differently than I do. And so I want to make sure that I'm trying to see things their way. Could you give me the definition of meaningful participation, please?
Chairman Gleason and members of the board, meaningful participation depends upon the context. There are many, many cases. There are more than 90 cases that use the words meaningful participation, at least in my research that I've done, and I've read all of those cases. And I can tell you that, in my opinion, what it means is the right to participate, to say what is on your mind, and the right to competently be present and have your concerns considered in a manner that is a fair process. That's the essence of meaningful participation. There are many different types of cases that discuss that term. Some of them deal with criminal cases, some of them deal with juvenile court proceedings, some of them deal with real estate matters. It runs across the board, runs across the gamut. In this case, there is no set definition for meaningful participation, but that is something that I think should rightfully be determined by the JPA board should the JPA be formed. And in this particular case, I note that Mr. Hoffman has presented what he thinks is meaningful participation, at least on the Groundwater Sustainability Plan Development Committee. And what he's referring to there, I think, is making sure that his client is a member of that committee. I respectfully submit that that is something that should be determined by the JPA board rather than your Board of Supervisors or anything before this JPA is actually adopted. I think what he really wants is a guarantee that his client will be on the committee, but that's something for the JPA board to consider in public so that it can be completely vetted and everyone, all members of the public, can participate in that discussion. So there is an opportunity for him and his client to get what they want. There is an opportunity for Mr. Steve Fodder to get what he wants. I also want to amplify the record to respond to Mr. Steve Fodder. I have spoken with Mr. Steve Fodder on the phone with you, and his attorney was aware of it. I have spoken with his attorney several times. We have had telephone meetings. I have spoken with his attorney in public in meetings in Ridgecrest. So the suggestion that Mr. Steve Fodder has been left out of the process simply is not an accurate statement of the facts. But I think what he clearly wants is a seat on the GSP Development Committee so that his voice can be heard. And I suggest that that is something that should be taken up by the JPA at the appropriate time. Thank you.
Thank you. A couple of things I want to talk about. First thing is Ms. Thomas. Thank you, Ms. Thomas, for what you do. Thank you, Ms. Thomas, for your words. I've spoken to you many times about my opinion about the RCD being on the GSA board in terms of voting and that kind of stuff. I was clearly, my thoughts were the members of the GSA board, the voting members, are elected officials, and the two non-voting associate members are the Navy and the BLM, and the fact that they're non-voting associate members is their decision, not ours, because of the relationship with the federal government and the state government. I also believe that it's important for any member of that board to have policing powers or some type of authority that they can bring to the table to have that particular help with those decisions and throw those capabilities on the table so we can work together to find solutions, because we're going to have to make difficult decisions. All that said and set aside, I've never ever said, nor do I ever have ever meant, and you've never heard me say that RCD isn't an incredible, valuable resource for how we're going to achieve success in that valley. And whether your best positioning, personally, I don't think it would be on the board. I think there's plenty of opportunity for the RCD to play a role and to help us get to where we want to go. I say that because of this reason. This pops in my mind right now. We got no money. The gentleman here talked about state funds, Prop 1 funds. Kern County's got no money. We've been throwing staff dollars at it for about 2 years now. Ridgecrest has no money. Indian Wells Valley's got some bucks, but we're trying to drive this as an estate, enterprise
fund.
Enterprise fund. Thank you.
Read your mind.
There's going to, so in my mind, and this is another thing I want to talk to Mr. make sure he hears loud and clear. My vision of this is we have a GSA committee supported and staffed by committees. Primary committee. There's going to be a finance committee. There's going to be in my opinion, there's all my opinion, finance committee. The board has all agreed, all the JPA board, to a GSP development committee. My opinion also, there's going to be a public outreach committee. There's going to be an assortment of committees. Each of those committees is going to have to work together to come together with a plan to forward it up to the GSA, because we don't have the staff. Those committees are going to have to be populated by local persons, volunteers, who are going to come to the table with some energy and some desire to see success. All those agencies, all those committees are going to have to work together, and they're going to have a funnel point to move that information to sit down. We have a board meeting so someone can talk about what's been happened. So I see, in my mind, the GSA coming out with some overarching strategies and say, we need a GSP developed. For example, we need a GSP. The GSP has to do this. It has to develop a plan, and it gives certain timelines. So there's going to be thresholds of performance and metrics that are going to have to be met across a period of time till 2020. So we don't get the whole thing in 2019. So there's going to be timelines, and there's going to be things that have to be achieved in certain, for example, we need an importation plan. We need a treatment plan or an analysis to find out if it's possible or not. How are we going to treat water? How are we going to properly and adequately define safe yield? All those things have to be done, and we don't have the staff to do it. There's no magic up here saying that we're going to be staffing this. It's going to be a local agency and a true collaborative effort. Whether or not you personally are, what level you play, I don't know. Just because you've got a lot of money doesn't give you advantage over someone who doesn't have a lot of money. But what it does give you is, insight. The fact that you're in the position you are gives you value to the committee. I don't deny that. I've said that time and time again, and I've never said that we're trying to get ag out of the valley. So there's going to be plenty of opportunity there for all agencies to work together in this GSP Development Committee. I think I've said that all right. There's an urgency to doing what we're doing. This law was signed in January 1st, 2015, and we have 2.5 years to get the GSA developed on the street. We're a year and a half into it, more than a year and a half into it, and we're still trying to get the JPA together so that we can submit for a 90-day window to form the GSA. So to say that we can tap the brakes, I don't think is really an adequate. I think there's an urgency to what we need to do. There's a timeline, there's talent out there that we need to try to muster to help us solve the problem, and I think it is urgent that we move forward. So I want to assure Mr. Stiefvater that I hope he heard input from me, and you can walk away with saying, okay, I'm going to have a role, or I will play some role in this GSP Development Committee. I heard Mr. Hoffman and Anita and Nettie used to hear the same thing. There's never been a statement from me about excluding private pumpers, Mr. Hoffman. There's never been a statement from me about conflict. There's only been a statement about collaboration. The only time conflict is from you. I hope that goes away. I think I've said everything I need to say. Anybody else?
Chairman Gleason, if there's no further comments, then we recommend that your board make a finding that the matter is exempt from further CEQA review pursuant to sections 15061B3 and 15378B5 of the state CEQA guidelines, approve the joint exercise of powers agreement to create the Indian Wells Valley Groundwater Authority, select a representative and an alternate to serve on the authority board, adopt the proposed resolution that's been submitted to your board, and authorize the chairman to sign.
Thank you, Council. Supervisor Couch.
Thank you. In Sigma, once a GSA is formed, they have to meet within, is it 45 days, Madam Council?
Chairman
90
or
days?
Supervisor Gleason, in this case, the JPA agreement itself says that there will be a first meeting of the JPA within 45 days, and that 45-day period actually runs in August. So there will be a meeting in August, regardless of, at least with the three that have already voted to form the JPA. The JPA was effective as of July the 1st.
Okay. I believe the words of our chairman, and that those types of committees that allow for that input will be created. I guess I'm asking if, do you intend to, or will that happen, or that discussion at the first meeting?
I think that it will not be agendized.
Okay.
But it will be discussed, if I'm the chairman, then it'll be my initial conversation is how do we let's construct the GSP Development Committee.
For any GSA, well, let me say it this way. I think it would be helpful for what we're doing over here, and maybe what you're doing over there, for every so often we get an update on actions taken by not only the Indian Wells Valley GSA, but any of the GSAs that are formed over here, meetings that have taken place, committees that have been formed, those types of things. And it doesn't need to be, I don't know what frequency I'm looking for, but just when something significant has taken place. So it would be nice to get that type of information back. Do we want to do that?
Yeah.
Give us a little report on that? Okay. I'll move the staff's recommendation. Thank you.
August 29th.
Second.
So can I understand this, that we are appointing me to be the primary member of this board and Supervisor Scriven to be the alternate, and then that we're authorizing chairman to sign the JPA?
You can include that in my motion.
And may I also,
satisfactory?
yes, and may I also correct the record, I misspoke. The JPA was effective July 15th, not July 1st. So the first meeting will be within 45 days from that date.
Outstanding. Okay, we have a motion and we have a second. Please cast your votes.
Motion is approved, all ayes.
Okay, moving on to item number 20, public hearing to consider possible election of the County of Kern to become a groundwater sustainability agency. The portions of the Kern County sub-basin of the Tulare Lake groundwater basin, which has been subject to notices filed by the City of Bakersfield, Kern Delta Water District, and Kern County Water Agency Improvement District Number 4, and Greenfield Water District. Pass this off to Ms. Lawson.
Mr. Chairman, County Council will be briefing you on this item as well.
Thank you, Chairman Gleason and members of the board. This is the time set for a public hearing to hear comments, consider and decide whether the county should file to become a groundwater sustainability agency for the portion of the Kern County subbasin of the Tulare Lake groundwater basin in those areas that are the subject of two proposed groundwater sustainability agencies. The first proposed GSA is called the Kern River GSA, and it currently consists of 3 voting members: the City of Bakersfield, the Kern County Water Agency, Improvement District 4, and Kern Delta. The second proposed GSA is one that has been filed for by the Greenfield County Water District GSA. SGMA, the Sustainable Groundwater Management Act, allows eligible public agencies to form GSAs. The county's SGMA jurisdiction encompasses the entire county. Therefore, your board may file to become a GSA over all or any part of the county pursuant to SGMA. However, your board has indicated a preference to work cooperatively with the other eligible agencies and become part of GSAs that are formed by other cooperating eligible agencies when possible. A substantial portion of the 2 subject GSA areas today are in the unincorporated areas of the county, which is significant. If your board wishes to form a GSA over the same areas that the Kern River GSA and the Greenfield GSA have filed over, then the county has until tomorrow under SGMA to file a notice of intent to form a GSA over those same areas. And that notice of intent must be filed with the California Department of Water Resources. The county's failure to file a timely notice will preclude the county from forming a GSA over those areas and will result in the 2 GSAs becoming the sole GSAs of each respective area. If your board votes today to file a notice of intent, it will trigger other portions of SGMA that will require the parties to meet and confer to try to reach an agreement regarding the areas of overlap in the GSAs. As a practical matter, this statutory meet and confer remedy is a very powerful tool to encourage the parties to reach consensus, because if no agreement is reached, the state can come in and take over the management of those areas under SGMA. It is our sincere hope, this is staff, that we will be able to continue to meet with the local agencies and reach an agreement. To date, county representatives, including staff, have met with the Kern River GSA and various of his representatives to address the GSA issues and concerns. Those issues have been, in my opinion, very productive and very positive. Those discussions are moving in the right direction towards a resolution, and an amicable resolution. In my opinion, with direction from your board, we will be able to reach an agreement that will hopefully allow the county to be part of the Kern River GSA in a meaningful way. I am also hopeful that the same will be true for the Greenfield GSA, and I have had a long discussion with Greenfield's attorney. Pursuant to SGMA, in order to preserve the county's legal rights, it's essential that the county file a notice to form a GSA over the Kern River GSA and the Greenfield GSA by tomorrow. If the county doesn't do that, the county will lose its legal right to be a GSA over those areas and will also significantly lose the right to trigger the powerful meet and confer requirements of SGMA that is likely to facilitate the county's inclusion in the Kern River GSA and the Greenfield GSA. Consequently, we ask that your board consider public comment today and provide direction to staff and direct staff eventually, ultimately, at the conclusion of the hearing today, to file the necessary notice of intent to form the GSAs and related documents regarding these areas. If agreements are subsequently reached after today, the county may withdraw its notices. And that concludes my remarks. Thank you.
Thank you, Madam. Open up for public comment.
Chairman Gleason, Board of Supervisors. I'm Rodney Paula. I'm chairman of the Kern River GSA. I'm also president of Kern Delta Water District. The letters I've given you just now should be exactly what's in your board packet, but just in case you haven't had a chance to read them, we've kind of flushed you guys with them since last Thursday. So I just want to make sure they're in your hands. What I really want to do is kind of walk through it just a little bit. It's somewhat of a brief letter. It wasn't intended to be an agreement. It's what we have come up with where we think we're in the same ballpark with the county. One of the things, it's been 6 weeks since you filed over the top of the BV Water District. At that time, I believe supervisors directed the staff to start meeting with the Kern River GSA and other GSAs in order to move it. It was not a very good start. We did not have much communication. Now, last 2 weeks, it's been a flurry of meetings, phone calls, emails between staffs, council, some supervisors, trying to find out what our differences were. What I kind of really realized, and I also appreciate the effort the county has put in. I understand trying to get the county to move sometimes is a little bit hard to get the engine started, but we think we've got it moving down the track, and hopefully it's the right direction. The discussions have been very beneficial, and we've narrowed them down to where we can agree in concept, and that's what this letter was all about. What was interesting was that we appeared to agree in concept, but until I had a couple one-on-one meetings, we didn't realize that we were speaking in different languages. We were all saying the same thing, but for whatever reason, our acronyms and our abbreviations and how we talk, the water agencies, and how the county talks, we just couldn't seem to ever figure out what we were saying the same things. So what we did was we came up with this concept of principles, basically in an attempt to reach an agreement with the county and to move our process forward. So I've identified, there's 11 issues here. I threw in an extra one that's not in your letter we'll talk about. The indemnification came up a whole lot. Pretty much the Kern River GSA is not planning on using the county's police powers. We don't really feel we'll ever need them, but we feel if we do, we'd be more than glad to indemnify them on a case-by-case basis. We think that's a very fair way of doing it. The other issue is if, for some reason, the county decides to become a voting member and we agree on how that works, then of course then there wouldn't be an indemnification because you become a voting member. Land use powers for me was probably the biggest misunderstanding I took away from the staff report. I heard it totally different. But what I gained to realize over our last few meetings between council, staff, and supervisors is pretty much the county does not intend to zone a specific project, then it's then expect the Kern River GSA or any GSA to provide extra water to that project than what would be historical used on that piece of property. Those numbers we can't even talk about until we get a GSA with a GSP that turns into how much water we actually get. We never thought we'd be fighting this hard in the simplest part of the whole process. Likewise, the other thing is we want to ensure that in the Kern Delta, we're an all-ag district. We have some incorporation with the county or the city. It's not our intent, or we do not intend to restrict any water inside our uses, such as it can only be ag. If the ground has a historical use, it will be allowed to have that. That is our intent. It's always been our intent. That's how our working relationship with the city is currently. So we turned out to be, that one item for me was the biggest one. We just appeared that we were walking down the same path. White lands, we understand the county feels the obligation to undistricted areas. I have a ranch that's actually split in half between Kern Delta and the white lands. So it's very important to me to watch what's going on with the white lands. And we've mentioned many times we're willing to work with the county on how to administer white lands. We don't really care to do them. If you want us to, we'll work jointly to figure out how you want us to administrate a white land area that's either inside our GSA or bordering or nearby one of our water districts. If that makes sense to you, both financially and everything else, and you tell us what to do and you want us to do it, that's great. We're way early trying to get that figured out. The county has to figure out what you're going to do with the white lands. Are you going to make its own, I hate to use improvement district. I was called down by an attorney that that's not the right word, but some sort of a group of people that could be taxed or levied or whatever to help with solve their water issues, such as water banking and stuff. It's really important to understand that the KRGSA did not file over any undistricted white lands. There isn't any. The city, Steve at the city, basically in his words, took a scalpel to our GSA. If you look at our plan, there's very few little pockets carved out. And the reason is those are undistricted lands. They're not represented by ID4, Kern Delta, or the city. So we didn't know what to do with them. We wanted to avoid overlap, so we left them out, thinking that if you want us to take them in, you would let us know. And if you want us to administrate them, you need to tell us what you want. I'm gathering that right now the county is still in this middle of this white land. What are we going to do? How we're going to do it? And it's a major decision that really lies on the county, and a lot of stakeholders, landowners are looking to the county for some sort of answers on that. Well permits, I know there was some concern from the city as far as well permitting goes. There's not a water agency I ran into that says, gee, we want well permitting. That's something that is not in our realm. If they want to collaborate with a water district such as Kern Delta and have some advice about what we think, that's one thing. But we have no intention to do anything in the well permitting. Water transfers, we understand this is an issue, but it's an issue for a district, just like it's an issue for the county not to let water go out of the sub-basin of the county. We don't know where we're going to be with water transfers. We have a GSA that we have to get accomplished. We have to have a GSP. You have your 2017 deadline to get formed, and we have to have a 2020 deadline that we have to have our GSP formed, and you have a 2040 date that has to be in compliance. Once the water amount is given in a particular, such as Kern Delta, we have permanent crops coming in like crazy. We estimate we'll probably be close to 50% trees and vines over the next 2 or 3 years. We have a huge water need inside our district, not counting housing that's moving in, development. To say that we're going to allow water transfer out of our GSA to somebody else that would wind up putting us in balance would be a suicidal mission that I know our board would not allow that, much less the GSA's board. The water transfer is something that needs to be talked about, but we're saying this is our opinion today by what we know, because we don't know how much water we're going to get. We can't right now say, great, the county, you guys want water transfers, we're glad to give those to you, but if we don't have, to me it's kind of a moot point till we really know what we're talking about. Protection of the average citizen. I circle Lamont on this. Kern Delta has already reached out to Supervisor Perez and staff that we're willing, we have come, and this was before all the GSAs, we've talked to Lamont over the time, There's lots of issues out there. I don't understand them all, but through our manager, I'm trying to learn. We're willing to help, and I think Arvin Edison is helping. There's Grimway out there. There's a lot of people willing to help disadvantaged communities. The way to make that work is to have a cooperative effort between the county and between the GSAs and between the water districts, and not more of a, we're starting off at a contentious stage versus a cooperative stage. And that bothers me a little bit when we're trying to cooperate here. The next thing was JPA versus MOA versus MOU versus, I mean, I've never seen so many abbreviations in my life. What we're proposing is basically a memorandum of agreement or a joint powers agreement. Now, a joint powers agreement would be somewhat like the city and county has in fire. It's not an authority. While both documents that could work, we don't see that a joint powers authority, not to be confused, a joint power agreement, is needed because there's not an intention to have a joint exercise of powers. If something happens that we have to administrate your undistricted land for you, then at that point, possibly a joint power authority might come into play. But to move this forward, we believe an agreement of some sort, whether a memorandum of agreement or a joint powers agreement, will suffice what we need to keep us moving. The next thing I think is very interesting is the voting. I've listened for the last 20, 30 minutes about item 19, Ridgecrest and all that. And you know what? It's a wonderful story. We just need to change the names a little bit, and it's exactly what we're talking about. So it has been an interesting watching where you guys we're ahead of you in that we formed our GSA. Now you're doing your JPA, but it's been interesting to watch this. We're willing to discuss with the county if you need a vote, want to vote, we have no problem with that. We just need to make sure you understand it comes with a cost. You need to be part of if you're going to be a voting member, what we have in our group is we all have authority of power over landowners and what we filed for, and we also brought water, money, counsel, and expertise of staffs. We're pretty much expecting the same thing out of the county to be a player in our GSA. We want, if you guys want to come in, our budget is bordering close to $1 million to do our GSA and the plan. Not so much a GSA, but moving on to plan. We had our experts come last week, gave them presentation. The other thing we learned also is that even with no hiccups in this thing, we're out to almost August of 2020. If everything goes according to plan, we might have a plan before 2020, August of 2019. We're cutting it close, and we're on the forefront of getting this thing started. So it is, the only thing I take in objection to what county staff has said or what I hear is on your item 20, it says there is no fiscal impact. And I go back to the point where Chairman Gleason, quote, county has no money, okay? In the last staff report, it said all we're going to do, this is not going to cost the county, we're just going to charge fees. Well, you're double charged, and we've had this disagreement, I think, already once before, but I'm going to state it again. The Kern Delta Water District is covering all the costs for the GSA and the GSP for their landowners through their assessments that we've already taken. If the county comes in and says, we're going to be part of the Kern River Group, and now we're going to add property taxes on everybody inside this area, we're paying double for what we're already paid for once. And so when it says there's no fiscal impact, that's because you're planning on passing fees. But we're hitting different consultations saying it's probably going to trigger a 218. You're going to have to get the votes. It's going to be a way different thing. I just think be careful when you say no fiscal impact, because one thing about water, usually in the same sentence as litigation. Be careful when you enter the water world, because it's a treacherous group. But what's interesting has been you would never thought. On the other hand, I never thought in the 20 years I've been on the Kern Delta board, been president almost 10 years, we would ever be able to work with the city. We just, in our natures, we can't. We've been fighting since 1974. The GSA has brought us together. We have since, in the last year and a half, we've had a couple projects we're working on, and all of a sudden now, by actually coming together and having to cooperate on a GSA, we've actually are forming an alliance that I never thought would exist. We also brought the water agency in, which sometimes we all have disagreements. But if you come to our working board, we have one of the best staffs put together I think you'll find in the county, all working together between all the agencies. I think that has been one of the biggest benefits I've seen in a GSA. Oil and gas, we acknowledge the importance of oil and gas. There's no way around oil and gas not being a major player in Sigma, but nobody's been able to tell us what is their role in Sigma. To stop a complete process because we're worried about what you're going to do about oil and gas, well, tell us what oil and gas, where the water is. They produce water. From what I understand, they're a net producer, not a net user of water. It comes from different aquifers. It could be a new water site, although Coelho and I think another water district's already doing programs with the oil industry to produce water usable. So there's a lot of stuff already going on within the oil and gas industry and the ag industry and water to get that going. One thing I want to touch on is it's been battered around representation on water boards by big ag only and how they control the boards. Let me tell you about Kern Delta Water Board. We have 9 members. It's like herding cats. You can imagine if you had 9 supervisors instead of 5, it's quite the challenge. We have our variation. We have everything from a farmer who owns 80 acres, and you all know you vote basically on a per acre valuation deal, to the largest landowner in the district. And we have everybody in between. We only represent, all 9 board members only represent 1/3 of the land in all the district. So to say it's controlled by big ag, it's really kind of a far-fetched statement when you're coming into our water district. We also, all the people on the board are multiple users. We got row crops, vegetables, trees, vine, and dairies all represented on that board. It's probably one of the most diverse group ever put together on a water group. At the end, we're trying to solve the July 19th deadline, which is today, which is tomorrow. You know, it's important to realize that all the water districts are watching this very closely. There's been some discussion whether why the county's doing it, where it's going, and I think a lot of it has to do is we did not have the conversations we needed at the beginning when we started putting it out in March. We think it's in county's best interest to resolve our issues sooner than later. But when we went through the list and we grilled at one of our meetings, we had staff, we had a supervisor representative, everything. What other issues have we not touched on? And I haven't found any. Unless somebody's come up with something new we don't know, we feel we're in agreement across the board on how to do it. You need to show that the county, by moving forward to this, you're showing that the county has concerns and you're willing to work with the concerns of all the future GSAs coming forward, and you're not just going to be the gorilla in a cage that can file over the top and stop everything. And then June 17, guess what? Everybody backs out, and now you're the cage. You know, you could be the GSA or where state comes in and takes over. I think by working with us through our process, it's going to pay dividends many times over in future GSAs and what's come up. A couple quotes I heard today: time is of the essence. Absolutely right. If we file over us today or tomorrow, a lot of debate what happens to our 90-day clock. We're at 90 days. Our GSP, we're starting to move forward with it. It truly does it could set us back, depends on, we're getting different conflict interest on that. Like I said, our consultant said that even if we go without a hitch from here out, we're up to probably August of 2019 to even get our GSP even close. And that doesn't count coordinated with, that's just our GSP. We have not went out. Now we have to coordinate with the Kern Groundwater Authority, if the county does the Whitelands. We have a long ways to go, and we need to start this off on the right foot. I wrote me a note during your speech, and I do know we can't tap the brakes, and whatever you said before that was pretty good too. There's an urgency. It's an urgency in what we're doing, and we can't tap the brakes. See, I paid attention to what you said. So we really don't have any disagreements is what I'm trying to head to. We urge you that we understand that, we hope that your intent's similar to ours. That we're trying to do this, trying to move forward. We know it's going to be painful to be on a GSA board to make the decisions that have to be made. And we need to get forward so we can figure these things out. Forming the area you represent should be the simplest part, and it's becoming the most. Our request is that although we'd like to hear, I think we're good people, we're good for a word, we want to get this thing done. Our attorney said they'd work tomorrow and get our agreement hammered out tomorrow so you wouldn't have to file over the top. I think Councilor Goldner cringes a little bit about that. But we understand that if you deem the feeling that you have to file over the top in order to hold our feet to the fire for the agreement, we're not really sure that that's necessary because what we have in here isn't anything new than what we've done all along. The other thing is, I learned a new word today I can use also is meaningful representation. We've been offering meaningful representation since March 19th to the county. We haven't really got any response until 2 weeks ago. We finally really started meeting, and that happened because 4 weeks ago, I instructed staff to reach out to the county. We got to get some meetings going here. So meaningful representation has been there for you in the definition of what Councilor Goldner. So if you feel you have to file and you have to move forward, then what we're requesting is that the supervisors direct staff to basically come back with an agreement either by next Tuesday or the following Tuesday. We're hoping within 2 weeks. The reason being is if we can come through with a simple MOA, JPA of agreement, if we can come through with that, your file could be rescinded and the clock keeps moving. It accomplishes what everybody wants and everybody's on their way. And then we can look forward to helping you guys when you decide what you're going to do on the Whitelands. That's it. The biggest thing now is basically overlap's only going to complicate our situations and harm both entities. It's just a matter of how we work it out. So, appreciate your time.
Thank you, Mr. Paula. Mr. Paula, could you wait just a second? Supervisor Maggott.
Mr. Paul, thanks for coming forward this morning, and I'm optimistic that we will work out our arrangement in a way that's suitable for everyone. I think you said you found an 11th issue and your list only goes to 10. So
on there is 10. The 11th one I threw in was representation by the Big Ag.
Very good.
Yeah.
Thank you.
That was the one that wasn't on there that I decided to talk about today.
Very good. Thank you.
Is that it?
Good morning, supervisors, staff. I'm Dennis Fox, and I'd like to talk to you about your loss of a planning tool concerning liquid material, which can go from one area to another very easily on the surface or under the ground. And that is by doing this with a negative deck. And since the operation of the water bank and the inauguration of a water marketing committee, the focus has not been on keeping a prudent reserve of groundwater and husbanding such supply as has been existed. This results in significant effects on the environment, including habitat loss, deteriorated air quality, and especially geologic and hydrologic impacts. As the only way to predict future in creating a groundwater management organization is to look at present ability to deplete the groundwater through exporting of both surface and water replenishment and groundwater pumping, any attempt at a negative deck is lacking credibility. While Merced County banned water mining for export as a measure to eliminate, if not mitigate, this scenario, it would not occur here for our economic colonial culture reasons. Thus, as other counties take local control for water that would have left their area, there will be less water for Kern acquisition and Southern California acquisition. This will result in a scarcity, cause price rise, which will incentivize groundwater depletion. Hardly a, quote, certainty that there is no possibility for no significant effects on the environment, unquote. Note also that satrapy on the county's part has directly involved physical environmental changes. 1, allowing trespass by a water exporter for a purpose of deliberate habitat destruction. Of course, such destruction policies necessitate fees placed on local home buyers for HCP mitigation acquisitions. 2, sale of county lands at bargain prices to an exporter, which can facilitate his water pumping and exporting. 3, tax policies which tax, quote, the locals, unquote, for water acquisition, pumping, and export, concurrent with giving the recipients of this water munificent tax exemptions. So, under current paradigms and policies, it can only be concluded that any negative declaration is neither valid or credible, and the continued focus on water as a commodity rather than a resource will actually diminish local water supply and importation to this area. Thank you.
Thank you, Mr. Fox. Anyone else?
Mr. Chair, fellow supervisors, I believe I had a Rosanna Dana moment when I walked in my haste and late, and it was item 19, not 20, so my JPA and planting that seed was for Indian Wells, but no, I was speaking about item 20. And thank you to Mr. Powell for herding cats and cooperating, but it's that nature, that spirit of cooperation that we need. And there's a lot of stakeholders, from big oil to food processors.
Mr. Lubon, would you state your name publicly for the record?
Benedict Lubon, L-U-B-B-O-N. And so many stakeholders in this game, and it could be a very a sound JPA that can get the money that's available, and time is money and time constraints, but Prop 1 money starts becoming available December 16th, and also with this food safety issue, we need to resolve it. So I'll be there tomorrow resolving it at the Central Valley Water Board. Hopefully I have public comment on the right item. You guys are looking at me like, I don't, Supervisor Couch was like, where are you coming from? You know, so altogether, I'll have something for you in writing, what we're thinking, and some of the initial groups that want to be part of the membership. Okay, thank you.
Thank you, Mr. Lubon. Anyone else? Okay, seeing none, I'm going to close the public session and bring it back to the board. And let me start off that, Mr. Paula, thank you very much for your comments and your words. I really enjoyed our conversation last week. Went over to the Kern Water Agency and met with you and other members of the Kern River GSA, proposed upcoming Kern River GSA, and enjoyed our conversation. Agreed with a lot of what you said today, almost all of it, especially with talking about the same thing, just using different words, and agreeing in concept to many of the things that you put out there. I think this county will find favorably. But before I go any further, Madam Council, do you have any comments that you'd like to offer about any things you heard today?
Chairman Gleason and members of the board, I do have some kind of legal comments on some of the issues, just very briefly to assist in your consideration of the issues, if you want me to go over that now. Okay, I'm going to go through the issues that Mr. Paula talked about today and that are in the letter that was provided to the county dated July 12th, received on July 13th. The first one is the indemnification issue. As a legal matter, I don't see any real issue with what they're asking for there. I don't see a lot of reason to disagree with that. On the land use issue, I think that it is important that any county response and any agreement with the Kern River GSA make sure that the county will have a continuous opportunity to participate in the preparation, review, and adoption of the GSP. And I think that we need to come up with I'll just call it a robust definition of the word participate, and make sure that there are ample safeguards in there to make sure that the county will indeed have the opportunity to do that. There are also issues related to the county's general plan, the zoning ordinance, and CEQA that I think do need to be addressed in any county response. Ms. Oviatt can respond to those if she wishes to do so now, but I think those are things that we need to consider and make sure that the Kern River GSA understands the county's position on that. I also think it's very important that that any agreement that we have with the Kern River GSA reflect that nothing that the GSP will do and no actions that will be taken by the Kern River GSA will modify, limit, or preempt the county's police powers, including its land use authority. I don't think that they're in disagreement with that, although I'm sure that we'll have a discussion over it as things proceed. With respect to the white lands, I think it's important to note that the Sustainable Groundwater Management Act does not require the county to manage the white lands, or as I refer to them, the white areas. Rather, it allows the county to do so, and in this case, I think it also allows the Kern County Water Agency to manage the white lands. So if the county decides not to manage the white lands, in my opinion, the Kern County Water Agency would be obliged to do so, or the state would take over management of those areas. So I think that's a topic that we need to discuss and flesh out with them as we work towards an agreement, hopefully with your board's direction. On the well permitting issue, I think we need to talk about some legal issues related to CEQA, because if well permitting moves from a ministerial decision to a discretionary function, then CEQA could be triggered. I want to make sure that there's an understanding on that. On the water transfers, that's a very important issue. I just remind your board that SGMA looks to the sustainability of the basin and not necessarily the sustainability of a particular GSA area. So I am sure that will be a hot issue that will be discussed as the GSAs move forward, but I think it's important that the public and the board understand that. With respect to the unincorporated communities, my sense of this is that Mr. Paula did indicate that Kern Delta had reached out to Lamont several times to help them with some of their water supply issues. I think it's important that the GSA, that we have some kind of an agreement that the needs of the unincorporated communities should at least be considered and actually addressed in the GSP. You know, what that's going to end up looking like, of course, is something for the GSA to determine. With respect to a JPA versus an MOA, a Memorandum of an Agreement, I agree that there are differing legal opinions on what is needed in this case. However, I think those are things that that can be worked out. Typically, a JPA is required when there's a joint exercise of powers. According to Mr. Paula's comments, it doesn't sound like he's anticipating a joint exercise of any powers, an exercise jointly of any powers. However, if the boundaries of the GSA are going to be changed in some way to include the white areas, it is possible that it might require a JPA, but those are things that the lawyers can hash out, and I am confident that these legal entity issues can be amicably resolved so that the GSA process can move forward. On the voting issue, that of course is completely up to your board, as all these things are. I do appreciate what the Kern River GSA said to me when I went to their meeting, when I attended it with you last week, Chairman Gleason, where they said that they were prepared to give the county a vote as long as the county was willing to pay to play, so to speak. On the oil and gas issues, I think that your board is going to be cognizant of the oil and gas industry's role, and I look forward to your directions in that regard. And those are really my legal comments that I have at this point. But I do ask that if your board decides to give us the authority and direct us to file over these 2 GSAs today, that you do so today so that we can meet the deadline. And if you want me to talk about the specific motion that I would request be made, I can do that now, or I can do that later. Okay. What I'm asking for you today is to close the public hearing, make a finding that the project is exempt from further CEQA review pursuant to sections 15061B3 and 15378B5 of the state CEQA guidelines, approve and adopt the resolutions that have been presented to you, electing to file a GSA notice for the portions of the basin that are the subject of this hearing, and those are all contained within your board packet.
Thank you. Mr. Powell mentioned something about coming back in 2 weeks with some type of, could you please explain that what he was talking about so the public clearly understands what opportunities there are to resolve this issue?
I think what he's hoping to do is that we will get direction from your board today about terms that may be acceptable to you, authorize staff to continue to work with the Kern River GSA staff and hopefully the Greenfield County GSA lawyer and their staff as appropriate to come up with a draft agreement that can be presented to your board. Whether that can be done in 2 weeks or not, I think is probably wishful thinking. I think it's more likely that a 30-day deadline is more practical.
Thanks. I just wanted to reiterate before I pass the mic how refreshing it was, Mr. Powell, talking to you, members of the city of Bakersfield, and have our conference and understand that we really are all trying to get in the same place. And I'm looking forward to the opportunity of working with you in any way, shape, or form that this board deems necessary. Thanks for your wisdom and your help. I'll pass this off to Supervisor Couch.
Thank you, Mr. Chairman. First of all, Mr. Paula, thank you for your comments today and for your reaching out to the county in the last few weeks and getting this process going. I credit you with that, and I appreciate it. County Council has provided us not only with her oral response there verbally, but we also have what I'll call a draft of some responses to the Kern River GSA's letter dated July 12th. And I've read through that, and I'm pleased with the responses, and I think they're on point, and I think that the Kern River GSA would be pleased to see them and receive something from us sooner than a month from now, though. I want to go back and talk about what were you saying that you would come back to us in a month with just a letter for our review? What were you?
Supervisor Couch, the chair, what I was hoping was that we could negotiate something, the CAA's office could negotiate something with the Kern River GSA and the Greenfield County GSA and have an agreement ready for your board within 30 days.
Within 30 days, but we're going to respond to their letter long before that.
Yes, once I get your board's direction.
Okay, well, I'm having read through the what I'm calling your draft responses. It's really just the draft really just addresses each of the bullet points in the letter from the Kern River GSA, and there's no more to it in this draft. It's not really a draft letter. It's just responses to those bullet points. So I'm pleased with those responses, and I don't really see a need to change any of them. And I appreciate your work on that. But do you think we can get this? Do you anticipate bringing us back a letter that we would see and then we would approve next week?
If your board gives me direction today, I will prepare a letter based upon your board's direction and send it out. If not, I will bring it back to your board next week.
Okay, I'm happy for you to take this as the framework of the letter, and you don't have to bring it back. You just have to get it to them as soon as possible, get the chairman's signature. I don't need to see it again. If it doesn't change from what I have in my hand right now, which is what you gave me, I'm good. Those are my comments, Mr. Chairman. And again, thank you for your hard work, and thank you again to the Kern River GSA for your willingness to sort of walk through this with us. We are learning a lot as we go, and we appreciate your help. Thank you.
Thank you, Supervisor Couch. Madam Council, does that require a discrete motion and vote?
Yes, it does. You do have the, I would suggest that it just be added to what I've asked for today on the record.
Okay, so we'll compile that into a motion.
Yes.
As we vote, and that would be to include your draft responses as the letter in response to the GSA.
Correct.
Thanks. Okay, Supervisor Scrivener.
Thank you, Mr. Chairman. I'll move staff's recommendation in addition to sending the letter. Also had a chance to review the draft. Thank you for your work on that. I think those responses are all on point. I'd like to also echo Mr. Couch and thanking Mr. Paula, the folks at the Kern River GSA, the folks of the city, and all the other agencies that are involved in that. I think we're really close, and I understand Mr. Paula's comments about some of the misunderstanding with the different languages that we speak. We're new to this water world to some extent, and I appreciate you giving us some consideration as far as that's concerned. So happy to make that motion, and thanks to our staff and also for the members of this board that have been involved so closely in the discussions. Thank you.
Second.
Supervisor Maggard.
Thank you, Mr. Chairman. I as well want to thank Mr. Paula and those that you represent for persevering with us. I think we are close to having an agreement. I am also in receipt of the memo that you sent us last night that amplifies the variations on the same letter that Mr. Paula sent to us on behalf of his organization, and I think it's very close to being resolved. We have reached out to oil and gas, and they've given us some of their perspective. I think we can fill in the blanks on those things where we had some kind of mutual misunderstanding. What I'm interested in is not delaying the process. So if she can communicate this to the Kern River GSA and they agree with the language that's here, I'm fine authorizing her to go ahead and execute the agreement as long as it is within the parameters of this. If it isn't, then bring it back in a week, and I'm fine with that too. But I would like not to hold it up, and I recognize the very long and arduous process that awaits Kern River GSA as they go forward to try and make it so. I'm comfortable having our motion today include language that authorizes her to execute the agreement on our behalf if it contains the language that is in the memo that you presented to us in that draft form. If my colleagues are also comfortable with that, I think a change in an amplification of the motion would be appropriate. But I'll be interested in what my colleagues think about authorizing her to proceed, if she can stay within the parameters of the draft she's presented to us.
Thank you, Supervisor Maggard. Supervisor Scrivener, are you willing to adjust your motion to accommodate Mr. Maggard's?
Perhaps. I'd like to ask Madam Council how she would feel about that. What's your comfort level?
And Mr. Chairman, it might be helpful if she gives the public some idea of what's in that draft. Just a public meeting. If you're okay with that.
Yeah.
The draft that I prepared last night was a draft of a proposed response to the Kern River GSA's letter dated July 12th. 2016. It is essentially a summary of what I commented on the record today. So I am happy to turn that into a letter response to the Kern River GSA and to move forward with it. If you board wants to delegate the authority to me to sign the agreement, I'm happy to do that. I suppose my comfort level is I would rather have the chairman sign the agreement. But if your board wishes to delegate that to me, I will do so.
Mr. Chairman, I'm actually more comfortable with having that agreement come back to be reviewed by the board in a public hearing, I think, and for us to authorize you to sign. I do appreciate that Madam Council did convey in her comments the content of, generally the content of the letter that she's going to send. I'd ask for the indulgence and consideration from the Kern River GSA just to allow us to have a little bit more time to see that process through, rather than authorize council at this point to sign the letter. I think I'd be more comfortable with that. Thank you.
Thank you, Mr. Scrivener. Supervisor Perez.
Thank you. Mr. Pella, I want to say thank you for your tone and tenor and the hard work in moving forward to be collaborative. Your comments earlier that working with the city of Bakersfield is treacherous is one that is, has been experienced by this county. I'm kidding. The city is fabulous. They're great partners, very important partners, and I think it's so cool that this process has brought us to the table in a way that we haven't been before. And I particularly appreciate the pointing out of Lamont their incredible complexities when it comes to issues of water and sewage and a whole host and array of challenges that community that's very near and dear to my heart has faced, because there are many like that throughout the county that I think this board really needs to be assured are not going to be left out of this process and are not be considered inferior to other interests that are well established, very sophisticated, and have really know the issues well and are represented well as they should be. So it is comforting to me to see that and to know that that is an aggressive part of your platform to think about these so many disadvantaged communities, not just in my district, but all throughout this county, that are rural in nature, that are poor, that are economically disadvantaged profoundly, and who absolutely need a place at the table in this conversation in order to make sure that that we have a balance as we move forward. So I want to say thank you for considering and caring for the community of Lamont, as well as every disadvantaged community in this county, and assuring this board that there is reason to trust this process beyond what is our own natural self-interest. So thank you for that. I would like to see the agreement brought back as well. I know you're working tirelessly to respond to these requests, but there are many concerns, obviously, and as we get closer, I've like my colleagues, every confidence that we're working through in a spirit of good faith and transparency. So thank you.
We have a motion and a second. Please cast your votes.
The motion is approved. All ayes.
Thank you very much. Which takes us to item number 43 on the Sheriff's Department. A request to set public hearing to consider increasing the vehicle registration fee from $1 to $2 for automated fingerprint identification program through the Cal ID system. Someone here from the Sheriff's Department? Oh, no, I guess that was pulled. So, Mr. Terpsey, would you please talk to us about item 43? Why don't you give it a second? Here, wait, let's wait for things to calm down a little bit.
I got you lunch, too.
Thank you.
Mr. Terpsey.
Thank you, Mr. Chairman. Mr. Chairman, members of the board, Michael Turnipseed, representing the Kern County Taxpayers Association. We too would like to congratulate Supervisor Perez with a new addition to her family. Good luck. I received an email last week from a taxpayer, signed phone number and email, not like many of the anonymous ones I receive, who had a question about this item, the 100%. The hearing date, setting a hearing date for 100% increase in vehicle registration fees, with the proceeds being given to the Kern County Sheriff Cal ID system. The increase in this will supposedly be used to purchase new equipment for LifeScan and biometric ID equipment. This taxpayer strongly objects to this tax increase on the basis its lack of voter approval. In addition to that, the amount of the tax increase will be nearly $750,000 per year forever. Given the fact that the Kern County Sheriff's Department currently charges fees for some of its activities with this equipment, the taxpayer questions the truth of the matter that the money will actually be used for the equipment, and he basically wants to ask that before you take action, what's your next hearing date, that you provide and have a review of revenues and expenditures under this program within the Sheriff's Department. If you have any questions, thank you for your time.
Thank you, Mr. Turnipseed. We got someone from the Sheriff's Department?
Good morning, Mr. Chairman, members of the board. My name is Tyson Davis, and I'm a commander with the Sheriff's Office.
Mr. Davis. Go ahead.
Okay. The California Identification Remote Access Network, or CAL-ID RAM board, was put into law back in several years back. I think it was 1997 when we started collecting the fees. What this money is used for is for the enhancement of law enforcement and biometric identification, or latent print, fingerprints most commonly referred to. Anytime someone's arrested, they're booked into the jail. They go through a fingerprint process. So the machines we use are called live scan machines. Those have a life, I can't tell you what the exact life period is, but they have a life where they wear out, and we have to replace them periodically. I believe we have approximately 18 of those machines across the county, and they're all expected to term out in the next year or so. So we're gonna have to start replacing those devices. What goes along with that is staff time, staff to monitor the infrastructure, and the storage. As everyone knows, we've come a long ways in technology, and the technology that's involved in storage of digital media, it's very expensive. So where we're at now with the RAM board funding is we're gonna run out of money to continue this process. Something else that's important about the RAM board is this is not just for the Sheriff's Office. This is for all law enforcement within the county. Now, the Sheriff's Office manages it, but it's managed under a board, and that board consists of several members throughout the community. Just off the top of my head, it consists of the sheriff, the chief of police of the largest police department, which is the Bakersfield Police Department, a chief from a smaller police department, a sitting mayor, a board supervisor, a citizen at large. I believe that's it. And they convene once a year. The Sheriff's Office staff who are charged with overseeing the funding provide a plan to that board. The board reviews the plan, and they vote on the actions of the plan. Then it's brought to your board for a final approval.
Thank you, sir. I'll open up for public comment. Anyone in the public wishing to make comment on this? You may sit down, Mr. Davis. Anybody in the public wishing to make comment on this issue? Now's your chance. Seeing none, we'll close public comment, bring it back to the board. Madam Counsel, do you have something to add?
Yes, I would. I would just like to bring to your board's attention the provisions of Vehicle Code Section 9250.9. There's a subsection, it's A-F, and it provides a statutory requirement for financial reporting to the state. And it's actually a very detailed financial reporting. I'm just going to tell you briefly what it is. Take me 30 seconds. It says, every county that has authorized the collection of the fee pursuant to subdivision A shall issue a fiscal year-end report to the controller, that's the state controller, on or before November 1 of each year, summarizing all of the following with respect to those fees. 1, the total revenues received by the county for the fiscal year. 2, the total expenditures and encumbered funds by the county for the fiscal year. Encumbered funds means funding that is scheduled to be spent pursuant to a determined schedule and for an identified purchase consistent with this section. 3, any unexpected or unencumbered fee revenues for the county for the fiscal year. 4, the estimated annual cost of the purchase, operation, and maintenance of automated mobile and fixed location fingerprint equipment, related infrastructure, law enforcement enhancement programs, and personnel created or utilized in accordance with this section for the fiscal year. The listing shall detail the make and model number of the equipment and include a succinct description of the related infrastructure items, law enforcement enhancement programs, and the classification or title of any personnel. And 5, how the use of the funds benefits the motoring public. So the request that's made on behalf of the Kern Taxpayers Association is actually contained within the statute and is something that the Kern County Sheriff's Office is already required to do. If they fail to submit that report in a timely fashion, subdivision F says that the controller will notify the DMV to suspend the fee for the county.
Ms. Davis, any comments? Thank you, Madam Council. Supervisor Maggart. I'm sorry, I didn't clear the queue. I'm sorry. Bring it back to, I'll close the public hearing, bring it back to the board for comment and consideration. Supervisor Scrivener.
Did you have a question, Supervisor Couch? Okay, I'll defer to you.
Is that, thank you, is that what you just described, the report that's required to be given to the state? It sounds like it would satisfy the request that Mr. Turnipseed asked for. He's nodding his head. Can we get those, is my question.
I believe that it would, and I would defer to the Sheriff's Department as to how quickly he can provide it.
Well, Commander? It was Commander, right?
Yes. Provide them at the next meeting or whenever the board hearing is set for this issue.
I would like to see it before that, if you could. So as soon as you could get it, and maybe at least a week prior to the. Sorry, is it August 9th that we're setting the date for? That's the action. Yeah, as quick as you could.
Okay.
All right. Thank you very much. Thank you.
That was what I was going to say. So, okay. So I will make a motion on staff's recommendation to set the hearing.
Second.
Motion second, please cast your votes.
Motion is approved, all ayes.
If I'm not mistaken, that brings us to the end. And I'm looking for a motion to adjourn to closed session.
So moved.